Hello students, welcome you all for the class of MBA Semester 3 Human Relations and Legal Framework. Today is our lecture number 33 and the topic of our today's discussion is Payment of Bonus Act 1965 Part 2. So in the previous session we will discuss some important provisions regarding the Payment of Bonus Act 1965. Okay. So today we are going to discuss about some other important provisions under the Payment of Bonus Act 1965. So the contents of our today's session are allocable surplus, available surplus, calculation of bonus, obligation of employer, rights of employees, recovery of bonus, offences and penalties under the uh, Payment of Bonus Act 1965. So in the last session we discussed about one of the scheme that is called as set on and set off scheme. That set on and set off scheme will be helpful to calculate the bonus. Okay, so for which first of all we have to calculate the allocable surplus and available surplus. Okay, so according to the provisions which has been made under this act, okay, in section 15, okay, that allocable surplus has been calculated. Okay, the process of calculating the set on values and set off values has been discussed in the fourth schedule of this act. Okay, so the provision has been made under the act how to calculate this value. So this is somewhat called as some sort of technical aspects to calculate the value of bonuses. So first of all we have to calculate the allocable surplus. Allocable surplus can be calculated for that particular company or any banking company according to the provisions which has been made, okay, under this act. Okay, so in relation to the employer being a company other than banking company which has not made the arrangement prescribed under the Income Tax Act for the declaration and payment within the India for of the dividends payable out of its profit in accordance with the provision of section 194 of the act, 67%, okay, of the available surplus in the accounting year. Generally that limit for that allocable surplus has been set to be 67%, particularly in case of foreign companies. Okay, in all other companies, particularly Indian or domestic companies, that allocable surplus would be 60% of the available surplus. So this is a technical aspect, so just we should have to keep in mind that while calculating the amount of bonus, so first of all we should have to take into account the gross profit. Depending on that we have to calculate the allocable surplus, and next is available surplus. Now this is called as the available surplus. So calculation of this available surplus can be made available in the section 5 of section of subsection 2(6). So available surplus can be calculated for that particular accounting year by means of considering the gross profit of that particular company after deducting some particular form of sums which have been mentioned under section 6. Okay, so this section 5 will provide how to calculate that available surplus. So available surplus is nothing but the whatever form of amount, okay, which has been there, okay, which should be calculated on the basis of gross profit by subtracting or deducting some particular form of sum which has been mentioned under section 6, provided that available surplus in respect of accounting year commencing on any day of the year 1968 in respect of every subsequent accounting year shall be aggregated. Okay, this process of calculating the bonus has been mentioned from 1968. So first of all we should have to calculate the gross profit. The gross profit of the accounting year after deducting therefrom the sum referred in section 6, okay, and the amount equal to the difference between, okay, two forms of terms has been there, okay, some amount has been calculated. That amount 1, okay, direct taxes calculated in accordance with the provision of the section 7 in respect of the amount equal to gross profit of the employer or immediately preceding the accounting year. So during that accounting year, or the previous accounting year, okay, here we should have to calculate the direct taxes, okay, and depending on that we should have to calculate that available surplus. Similarly, in another case, direct taxes has been calculated in accordance with the provision of section 7 in respect of the amount equal to the gross profit of the employer of for such preceding accounting year, after deducting some therefrom some amount of bonus which the employer has to pay is liable to the pay for his employees in accordance with the provision of the act. Okay, so in other case, first of all, the direct tax has been calculated, and depending on some sort of conditions which has been specified under this section 5, okay, that available surplus has been calculated. So let us see one example how to calculate the bonus over here. That is called as calculation of bonus. Okay, so while calculating the bonus, okay, the bonus generally has been calculated on the basis of gross profit of that particular company. Okay, those who are being employed, those who are being employed, certain kind of employees, and they are in a position to pay the bonuses to their employees. So okay, so in the first schedule, okay, the banking companies are being considered, and in second schedule all other companies, okay, all other employers has been considered. Okay, so there are specific conditions which have been made how to calculate the gross profit for these companies, or for banking company and all other companies. Then we have to calculate these two values. The first value is called as available surplus. Available surplus is equal to A plus B. Now what is A? Okay, A means what? Okay, A means gross profit minus depreciation admissible under section 32 of the Income Tax Act minus development allowances minus direct taxes payable for the accounting year calculated as per section 7, okay, minus sum specified in the third schedule. So okay, so gross profit minus some particular form of observations, okay, which has been mentioned in this case. Okay, so value of A will be calculated. Similarly, the value of B will be calculated, okay, and it is equal to direct taxes calculated as per section 7 in respect of the gross profit for immediately preceding the accounting year minus, okay, direct taxes in respect of gross profit as reduced by the amount of bonus for immediately preceding the accounting year. So in this way these two values will be calculated when we will make the sum of A plus B, okay, A and plus B, then we will get the available surplus. Then we will get the available surplus. Okay, after getting the available surplus we have to calculate the allocable surplus. Now how to calculate that allocable surplus? So allocable surplus is nothing but 60% of the available surplus. Okay, so in the last stage that we saw about, okay, the available surplus. So 60% of the available surplus will be equal to, okay, allocable surplus, particularly in case of Indian or domestic companies. Okay, 67% in case of foreign companies. Now in this way we should have to calculate the allocable surplus. Okay, thereafter, okay, some sort of adjustment has been made under this section by means of calculating the set on values or set of values. Okay, the value of bonus would be lies in particular form of limits over there. So for calculating the amount of bonus in respect of the accounting year, allocable surplus is computed after considering the amount of set on and set off from the previous year. Okay, which has been illustrated in the fourth schedule. So how to calculate that set on and set off values has been mentioned in the fourth schedule of this act. Okay, finally whatever form of allocable surplus would be there, either 60%, okay, in case of Indian companies, or 67% in case of foreign companies, that should be distributed equally among all the workers, among all the employees. Okay, that will be called as bonus. So in this way we should have to calculate the bonus. So the allocable surplus is computed is distributed among the employees in proportion to the salary or wages received by them during the relevant accounting year. So in this way we are calculating the bonus of the respective employee, either for suppose say the Indian companies or the foreign companies, and that should be distributed according to their salary or wages. Say for example, in case of employees receiving a salary or wages above rupees, suppose say 3500, okay, above rupees 3500, the bonus payable is to be calculated as if the salary or wages were 3500 per month only. So according to considering the whatever the salary of that respective employee, okay, the bonus will be calculated. So in this way we are going to calculate the value of bonus, and it should be distributed among all the employees. Okay, so first of all we have to calculate the gross profit, then the uh, uh, the allocable surplus. Okay, okay, and then we should have to calculate that allocable surplus. Okay, then we should have to calculate that set on and set off values using the fourth principle, and finally whatever will be the allocable surplus. Okay, it is suppose say 60% of that available surplus. Okay, or in case of Indian companies or in case of foreign company it is 67%, that should be distributed among all the employees as a form of bonus. Okay, so in this way the employer will distribute this bonus to the employees. Then obligation of the employer. Okay, there are certain form of obligations has been there. Generally those are called as duties. Okay, that should be followed by the employer to distribute the bonus, okay, appropriately. So it is the duty of the employer to calculate the bonus annually, and it should be distributed among the employees. They should have to also submit some form of annual returns of bonus if the bonus has been paid to the employees during that particular year. In form D, okay, there is some technical aspect that has been related to the act. That information has been provided via in form D, okay, to the inspector within 30 days of the expiry of time limit specified for the payment of bonus. So that information could be made available from the employer, okay, in form D, and to be submitted to the inspector. To cooperate with the inspector and produce before him whatever form of registers and record, okay, which has been maintained to calculate the amount of bonus, and how does that information could be made available to them, to the inspector. To get the account audited as per the directions of the labor code or tribunal or any other such authority. So time to time such form of records, registers, and whatever form of accounts has been supposed to be there, that it should be appropriately audited as per the instructions given by the labor code or the industrial tribunal. So these are the primary duties. There are some rights of the employer. Okay, so right to forfeit the bonus of the employee. So any of the employer, they can forfeit or confiscate the amount of bonus, and they could not distribute the amount of bonus to the employee, particularly in which situation when the worker has been going to be dismissed from the service, okay, due to fraud, okay, retious or any violent behavior, theft or misappropriation, sabotage of any property of the establishment. So if any of the employer that they are involved in any kind of indisciplinary situations, particularly they were conduct any fraud or any retious or violent behavior, they are involved in theft, misappropriation, or sabotage of any property, so employer is having a right to confiscate or forfeit the amount of bonus. So depending on some sort of investigation, the employer will decide whether they need to distribute the amount of bonus to these employees or not. Right to make any permissible deductions from the bonus payable to the employees, such as festival, interim bonus paid, or financial loss caused by misconduct of the employee. The employer should also has some sort of particular form of rights, so they can deduct the amount of bonus from the employees salaries and wages. Okay, if the employer has been previously paid some sort of festival bonus or interim bonus, okay, or any sort of financial loss caused by the misconduct of the employees. So they can recover that amount of bonus by means of using some deductions. Right to refer any dispute relating to the application or interpretation of any provisions of the act of the labor court or labor tribunal. So some sort of provisions has been made under the payment of bonus acts by means of using labor court and the labor tribunal. So they can the employer can refer the dispute to this labor court or labor tribunal, okay, in case that the employer has been not been satisfied due to whatever form of bonus related activity which has been paid to the worker. Okay, so if the worker suppose they had the legitimate right to ask the employee to get the amount of bonus, but due to certain uh, complications, okay, or whatever form of provisions which are available in the act which are not supporting in that case, okay, so they can refer the dispute to the labor court or labor tribunal also. Then rights of the employees, okay, each and every employee would have the right to ask to get the bonus from the employer, okay. So right to claim the bonus which can be payable under the act, okay, this is the very important form of provision which can be made under the payment of bonus act 1955. And also make an application to the government for the recovery of bonus due or unpaid within 1 year from becoming due. So any of the employees, okay, those who are being belonging to that particular employment, okay, particularly in the factories or in that certain employment, okay, they can ask for the payment of bonus, okay, which has been due from the employer, so within that particular year. Right to refer the dispute to the labor court or tribunal, okay, employees to whom the payment of bonus does not apply cannot raises the dispute regarding the bonus under the Industrial Dispute Act, okay. So some sort of provisions has been made under the labor court and industrial tribunal, okay. So employee can directly apply for make an appeal to these authorities and ask the payment of bonus, okay. But this act does not apply, okay, particularly considering whatever form of provisions which has been made under the Industrial Dispute Act. Right to seek the clarification and obtain the information on any item in account of the establishment. Even employees of the respective organization, they can ask for any sort of clarification from the higher authorities regarding the account of the that particular establishment and how does their wages as well as bonus has been calculated. So they can seek any sort of clarification and obtain the information from the employer. So these are the rights of the employees, okay, which could be made available under this act. Then recovery of bonus, okay. Now that recovery of bonus can be also made available from the respective employer if any of the employer that those who have been refused to make the payment of bonus. So there are some provisions has been made, okay. The employer has to pay the whatever the amount of bonus has been supposed to be there to their employees, okay. So where any bonus is due to an employee by the way of bonus, employee or any other person authorized by him can make an application to the appropriate government for the recovery of the money due from the employer. So any employee, okay, those who are being belonging to that particular industry and that employer has been not been paid any sort of bonus to these employees, so that employee could make an application to the government or to the appropriate authorities and ask for a bonus also. If the government is satisfied that the money is due from the employee by the way of bonus, it shall be issued the certificate for the amount of the collector, okay, who then recovers the money. Okay, once the government has been satisfied the payment of bonus has not been paid from the employer to the respective employee, the government will direct that information to the collector, and the collector will have the powers to recover the amount of money in the form of bonus and distribute that amount of bonus among the employees. Such application shall be made within 1 year from the date on which the money becomes due to the employees. So particularly whenever that amount of bonus has not been paid, from last 1 year. Okay, so within the prescribed period of time, the respective employee should have to approach to the appropriate government. Okay, then and then only the government will direct to the collector, and collector then recovers the money and then distribute to the respective employees of that particular organization. However, the application has been entered after the year if the application applicant shows that there was sufficient cause of not making the application within time. Okay, if there will be a delay in making an application to the government, so it should be mentioned clearly in the application why such kind of delays has been happen. Okay, particularly for asking the payment of bonus from the respective employer, and what sort of difficulties that they were encountered, and why does the employer has still not paid their amount of bonus. So all these things has been mentioned in the application to the government, and then the government will direct to the collector, and finally collector recovers that amount of money as a form of bonus, and then it will be distributed to the employees. The next one is called as offenses and penalties. Okay, now all the employers they will be liable to pay the amount of bonus as per the provisions which has been made under the Payment of Bonus Act 1965. If the employer suppose that they are not paying the amount of bonus, okay, to the respective employees, so they will be liable to get the penalty from the respective authorities. Okay, so for contravention of the provision of the act or rules, penalty is imprisonment up to 6 months or a fine up to rupees 1000 or both. So if any of the employer, those who are not paying the amount of bonus to the employee, okay, and its appeal has been made under the respective authority, so the respective authority can take decide and decide the award in the form of imprisonment for 6 months or with fine of rupees 1000 or both to that particular employer. For the failure to comply the directions or requisition made, the penalty is imprisonment up to 6 months or fine of rupees 1000 or both. Okay, if any of the directions with respect to the Payment of Bonus Act which are not being followed by that respective employer, so that respective employer will be liable to get the penalty from the respective authority, okay, in the form of imprisonment up to 6 months or fine of rupees 1000 and both also. In case of offense by the companies, okay, there are some particular organizations, okay, so that is called as companies, firms, body corporate, association of individuals, okay, its director, partner, principal officer responsible for the conduct of business in any case may be shall be deemed to be guilty for the offense and punished accordingly. If any of these person, those who are belonging to some particular industry, okay, in case of non-payment of the amount of bonus to the respective employee, so according to the provisions which has been made, okay, all these persons are being deemed to be guilty, and they will be announced with an award of imprisonment up to 6 months or fine of rupees 1000. Okay, unless the person concerned proves that offense was committed without his knowledge or that he exercised all due diligence. Okay, if in case, okay, without the knowledge of the above person the things has been happening, so that is need to be proved, okay, to that particular authority, particularly labor court or industrial tribunal, then and then only some sort of relaxation could be made to the employer or the persons those are belonging to the employer. Otherwise, in case of offense, okay, which has been repeatedly conducted by that respective employer in case of non-payment of the amount of bonus to the employee, okay, that employer would be liable to get some sort of penalties, particularly imprisonment up to 6 months and a fine of rupees 1000 or both. So that's all for our today's session. Thank you very much.